Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to talk to you about how you can make proactive use of time, especially in felony DUI cases. Now, felony DUI cases in California could be really a felony for one of really two main reasons. One is you have 3 or more priors within 10 years, and your fourth one could be charged as a felony. But more often what we see are even first-time DUIs where there's an accident, someone's injured other than yourself, and someone's injured pretty seriously. And or if you have a really high blood alcohol level and someone's injured moderately. And what we see is you could be charged as a felony, Vehicle Code Section 23153A or B, DUI with injury. And depending on the severity of those injuries, the district attorney could allege that you caused great bodily injury, in which case you would be subject to up to 6 years in state prison if you were to be convicted of the substantive DUI with injury charge and the great bodily injury. But this video, I want to focus more on what you can and should be doing, whether you have a good case to fight all the way, whether you're really not sure at this point, or whether you have the worst case in the world from a factual standpoint, and everything was done beautifully by law enforcement, from the drawing on the blood, from the preliminary alcohol screening device, from the field sobriety test, from the traffic stop, from the search, anything and everything under the sun. It does not mean all hope is lost. And if you have not had this discussion yet with your attorney and with your law firm about what you can be doing to be proactive in the downtime between court appearances or before the first court appearance, you should. And if your attorney is resistant to things you can or should be doing and is sort of blowing you off and taking that as sort of you challenging their abilities and, hey, don't tell me how to do your case, you might want to think about making a change, because there are a lot of things that over time, particularly in the last few years, starting in 2020 through 2021, 2022, and likely into 2023, with delays in courts, with delays still from COVID backlog, with delays in getting enrolled in DUI programs and everything that goes with it, you can make effective use of that time to differentiate yourself from everybody else who's charged with what you're charged with. Everybody else who has a felony DUI with injury pending. Everybody else who might have been 2.5 times the legal limit with the felony DUI pending. Everybody else who might not have a great defendable case if the case were to proceed to trial, right? Because that's what all this is about. Otherwise, you're going to be lumped in with the masses, and what's going to happen is you're going to get the same result as the masses get. And that's not going to be something that you're going to want. That's not going to be something that's going to be acceptable to you. And even worse, if you pay a significant amount of money arguably you might not have even had at first and had to come up with or borrow to get the same result as everybody else, that's not what you're in it for, right? My firm is really big on differentiating ourselves from everybody else who does criminal defense in San Diego, from everybody else the judge sees in court, from everybody else the district attorney interacts with in court, from everybody else a court reporter, court staff, anybody and everybody sees. But it's not about us. It's also, especially in a courtroom, more so about our clients and differentiating our clients from everybody else to ensure they receive as good, if not a better result than anyone else could get them, than anyone else could possibly get on the facts of the case. And that, to a degree, has a lot to do with how proactive you are. In a DUI with injury case, if you need treatment, are you proactively getting treatment? Right? Are you proactively enrolling in a DUI program? Are you going to counseling if that's appropriate? Is it something where you could proactively get on scram, alcohol monitoring device? Is there a way to craft the time from your arraignment, your first court appearance, until when the case eventually resolves, where as a condition of your bail, you were ordered to have something known as CPAC, CPAC in San Diego with SoberLink, monitoring your alcohol, house arrest, right? Well, why would you voluntarily do that? Like, well, what kind of an attorney would tell you to do that? Well, one that is thinking big picture, because you're getting custody credits for that if you're doing it right, right? So if you ever have to get a jail sentence, you will get credit by the time you're on house arrest. And who wouldn't rather stay in their house and be able to go to programs, presumably be able to go to work, be able to go to treatment, as opposed to sitting in county jail? no matter what year, no matter what time in history, COVID, not COVID, whatever, who would want to be in county jail, particularly who would want to be in San Diego County Jail with all the things going on in there the last couple of years, all the deaths, all the abuse, all the mistreatment, all the incompetence. It's no place to be. No place to be. Be proactive. Don't be reactive. That includes who you hire to represent you. If you find yourself, you or a loved one charged with felony DUI, or any crime for that matter, you want to be proactive, not reactive. That includes who represents you. We're just one phone call away. We'd be more than happy to help you, more than happy to point you in the right direction with the case evaluation. 619-295-3555. Again, David Shapiro, San Diego criminal lawyer.